Okay, everyone, welcome to Florida's second DCA, a year in review of significant opinions for the year 2020. My name's Colin O'Brien, and this is a free Florida bar approved CLE. If you are, do you mind muting? If you're not muted, do you mind please muting? If you are live here on Zoom, if you go to the chat function, I'm sending you a copy of the CLE demonstrative that I'm going over. And if you are watching this recorded, email wizard@floridadcawizard.com for a copy of the CLE. If you are not on mute, do you mind please muting? Okay, so this is a free 1 credit hour Florida bar approved CLE. This number here on your screen is the number you're going to need to use to get your credit on floridabar.org. This CLE is on Zoom and it's being recorded. So just so you know, it's being recorded live and it will be rebroadcasted. This CLE is being conducted by the Florida DCA Wizard LLC, which is my for-profit company that provides real-time case law updates of DCA decisions as they come out, and bullet point summaries and links to the cases so you can investigate more. This CLE is free and it will cover significant opinions for the entire year 2020 from the second DCA. I reviewed every single DCA opinion, second DCA opinion this year, and there were over 500 of them. And I've selected approximately 70 to go over in various practice areas that hopefully is enough of a wide net that it'll be helpful. Something in here will be helpful to everyone. These are my subject areas that I grouped them in: some discovery cases, summary judgment cases, contracts cases, some traffic stop cases, some negligence cases, some tort cases, some injunctions cases, notice and condition precedent. If you're not muted, do you mind please muting your, just making sure you're on mute?
I'm hoping.
Some miscellaneous cases, some sanctions cases, some arbitration/independent judgment cases, some motions to suppress cases, cases about complaints and affirmative defenses, some criminal law cases. These are my summaries, and as we go through, there are hyperlinks to the cases so you can read them yourself. There's some of these opinions are very long. You can spend a lot of time on them. So I'm giving you what I believe to be significant issues that come out of the cases that could be helpful or instructive in other scenarios. So the first set of cases are discovery cases, and let's go through them here. Each group of cases has the summary of what the cases are, has a hyperlink, and it attributes the trial court judge's identity to the opinion. Obviously, these are appellate decisions, but you may or may not find it helpful to have the trial court attribution there. So the first case is Lewis versus Splenda. It's Judge Stevens out of Hillsborough County. And there was a breach of a non-compete agreement and tortious interference. And the trial court ordered the production of bid documents, despite the argument that there was a trade secret privilege. And the trial court refused to do an in-camera review of the bid documents. And the second DCA overturned that decision, saying that on remand, the trial court should conduct an in-camera inspection of the requested bid documents to determine whether they contain trade secret information. So trade secret objection, there has to be an in-camera review of the documents. Next case, United States Automobile Association versus Bay Area Injury Rehab. It's Judge Huey out of Hillsborough County. If you are not on mute, do you mind please muting your device? Thank you. It's a little bit of feedback from somebody. This case, you feel bad for the lawyers in this case. There was a hearing on attorney-client privilege and work product objections, and the lawyers, they lost the hearing and they wanted to appeal The problem is they didn't get the documents into the record. And the second DCA affirmed the order denying the attorney-client privilege and work product objections because the documents weren't in the record. Nothing indicates that USAA ever followed a proper procedure for filing the 60 documents under seal with the trial court. I know you probably have all been there. How do we get stuff under seal? Do we just hand it to the court? And the second DCA said, the documents are not in the trial court's record and they cannot be transmitted to this court for review. So the documents were not in the record, could not review the attorney-client privilege objections. Now, one thing that was interesting is the party that was trying to get the privilege objections reviewed said, well, we gave the documents to the trial court and the trial court's office said, pick them up or we're going to destroy the documents. So we figured, sort of like osmosis, the trial court had it, isn't that good enough to get it in the record? And the second DCA was pretty harsh about it. They said that the USAA cannot blame the trial court for its own failure. If you've just joined, if you go to the chat function, there's a copy of the demonstrative and there are hyperlinks to the cases. We're on the third case in. So the point of this case, this Bay Area injury rehab case, is get your documents in the court record appropriately if you need to seal them. There's sometimes can be confusing, but if it's not in the record, the second DCA will not review your objections. Okay, next case, Samsung versus Hildreth. Judge Brody out of Collier County. There was a vaping device, alleged defective battery. It was one of many cases across the country. And there were some documents regarding Samsung's trade secrets that the plaintiff wanted to share with the plaintiffs in the other jurisdictions, and the trial court allowed that to happen. And the second DCA reversed, saying that the plaintiff did not prove that the documents would be discoverable in the other jurisdictions or even relevant to the collateral litigation. And the second DCA also took issue with the trial courts shifting the burden onto Samsung to prove why the other plaintiff shouldn't have the documents. So that's the case about sharing documents in other jurisdictions. Next case, Hepco Data versus Hepco Medical. Judge Minkoff out of Pinellas County. There was litigation over certain ownership rights to data generated from a foot sanitation device. And there was a blanket order denying a motion to compel 18 depositions, and then there was a protective order without any explanation. And the second DCA reversed that decision, saying, I'm quoting from the case, when a party is denied the right to depose an alleged material witness without a finding of a good cause to preclude the deposition, the trial court departs from the essential requirements of the law. This is important to know. If you're trying to get a protective order, you need to have good cause in the order. And there's a great quote from this case. If you're on the other side of someone trying to block discovery, the quote is, neither the rules of discovery nor the courts of this state have held that a party must rely upon the representations of opposing counsel as to whether the requested discovery is relevant. Apparently in this case, the other side said, you don't need the documents, it's not relevant. Believe us. And the second DCA put this great quote in there. If you ever deal with an objection like that, it's not relevant, believe us. Okay, next case, Collier Clerk versus Doe. This is Judge Hayes out of Collier County. There was a victim of sexual assault and she wanted to keep her identity anonymous. And the clerk of court accidentally disclosed her name in a docket entry. So the clerk of court was sued for violation of privacy. And the second DCA found that the clerk of court could not be sued. There's no statutory or common law duty to the plaintiff, and the case was dismissed. It's a little surprising because anyone who's filed on ePortal sees the big disclaimer. If this is confidential, you can get into a lot of trouble. Don't file anything confidential. But apparently, the clerk of court cannot be sued for disclosing confidential information. Obviously, the second DCA felt very bad for the plaintiff. Our decision today is no reflection as to the seriousness of the harm asserted by Jane Doe in her complaint, nor should it be construed in any way as a minimization of the great importance of protecting crime victims. Okay, if you're just joining, go to the chat function for a copy of the demonstrative. Next case is Avatar Property versus Jones, Judge St. Arnold, Pinellas County. There was a breach of contract case, and the trial court had a hearing on some objections to discovery. And at the hearing, this concept of work product was discussed, and the judge said, well, you waived your work product objections because I don't see a privilege log filed. And the second DCA reversed that decision, saying that, and I'm quoting, the party's obligation to file a privilege log did not mature until the asserted non-privilege objection was resolved. In other words, the party did not have to file a privilege log with a non-privilege objection. What the second DCA said here, and it's pretty interesting, it says that some practitioners are confused about this, that once the non-privilege objections are dealt with, then you deal with the privilege log, which is a separate issue. So a privilege log and non-privilege objections don't have to be filed at the same time. So the second DCA reversed the decision. Okay, next case, Progressive versus Hertzhoff. This is Judge McHugh out of Sarasota County. And it was insurance coverage regarding a boat. If you're not on mute, do you mind please muting your device? Thank you. And the trial court ordered the production of a claim file that did not result in litigation. And the trial court's analysis was, how can there be work product privilege? Because the claim didn't result in litigation. So by definition, there's no work product privilege. And the second DCA reversed that, saying, and I'm quoting from the case, no Florida court has held that materials prepared in anticipation of litigation lose their work product protection simply because a lawsuit never materialized. This is about the prospect of possible litigation, not whether actual litigation ensued. Next case is Het versus Barone Lundy. It's Judge Bonner out of Sarasota County. And this is a lawsuit regarding civil theft and about someone experiencing mental decline, and bank accounts were allegedly pilfered. And the trial court ordered the production of financial records from the trust bank and then law firm accounts. And the second DCA reversed, finding that the court should have held an evidentiary hearing regarding the financial records for the trust, and regarding the law firm's accounts should have, law firm's records should have done an in-camera inspection. If you are not on mute, do you mind please muting? Thank you. So this is a good case to follow. If you need to object, you got to have an evidentiary hearing, and the court has to do in-camera inspection. Okay, those were some discovery cases. If you just joined a little late, this CLE is free. The whole year, second DCA 2020, there were over 500 opinions. I selected 70. I tried to create some continuity in some of the subject areas. Each of the cases have hyperlinks. You can read the cases yourself. I'm giving you top line summaries that I think would be helpful going forward that are significant. So we just got done with some discovery cases. Now we're on to some traffic stop cases. There are 4 I picked out. The first one is State versus Brooks. It's Judge Thomas out of Hillsborough County. And the police there had probable cause to arrest for an expired temporary tag. In the absence of some evidence that the expired temporary tag belonged to that car, the police had probable cause to believe that Brooks was committing the second-degree misdemeanor of operating an unregistered vehicle. Pretty straightforward, but good if you're a criminal defense practitioner trying to deal with this sort of traffic stop issue. Okay, Green versus State, Judge Kaiser out of Hillsborough County. There was a traffic stop for a broken taillight. Now, and that was unlawful. I put 8:45 a.m. because that may have made a difference in the case. But in any event, the second DCA found that that traffic stop for a broken taillight was unlawful. And I'm quoting from the case, the state failed to present a particularized basis to suspect that the vehicle was unsafe, and it is not objectively reasonable to believe that a vehicle with a single broken taillight emitting some amount of white light, but which was otherwise covered with red tape, would be unsafe where the vehicle had 2 additional fully operational brake lights. I guess the car was duct taped and that was okay. Pretty interesting case. Bauman versus State, Judge Eiton out of Manatee County. There was a traffic stop based on an anonymous tip, and this was unlawful. I'm quoting from the case. The deputy did not independently corroborate the need for a stop. He acted solely pursuant to an anonymous tip containing a vague request for police assistance and a nebulous description of a vehicle. He stopped a vehicle that only faintly matched the scant description. Good case for traffic stop practitioners, criminal defense practitioners. Next case, State versus Brookins. Judge Twine out of Hillsborough County. And this search incident to a traffic stop was lawful. The police smelled marijuana coming from the truck, but the trial court actually had suppressed the evidence from the stop. And the trial court's thought was, and I'm quoting from the opinion, the marijuana gave rise to the right to detain, gave rise to the right to investigate. It even gave rise to the right to search the vehicle or any of those things, but that was not enough to search Mr. Brookins. Just because they smelled marijuana didn't mean they could search Mr. Brookins. And the second DCA reversed. And one issue I don't know that the trial court took into account, but one of the passengers told the police that Mr. Brookins had been smoking marijuana. I think that might have been the deciding factor, but Mr. Brookins didn't need to be arrested for marijuana for the search to be lawful. And the police smelled marijuana and totality of the circumstances. So the second DCA said that search was fine. Okay, now on to some notice condition precedent cases. The first case, HSBC versus Sherman, Judge Campbell out of Pinellas County. There was a second foreclosure case after the first case was dismissed without prejudice. And the bank didn't send a pre-suit notice for the second lawsuit. And the second DCA said that the pre-suit notice for the first lawsuit was sufficient for the second lawsuit. The second DCA found because the instant complaint alleged the same breach as the previous complaint, HSBC was not required to send a new notice. Next case, Hawk versus Triad Insurance Company, Judge Boyer out of Pinellas County. A corporation was in litigation. It failed to file its annual report. It didn't pay the required fees and became administratively dissolved. And the second DCA said that the corporation was allowed to continue to litigate to wind up its affairs. Statutory construction analysis, there's a lot going on in the opinion, and that's the law. If the corporation fails to file its annual report and fails to pay its required fees and becomes administratively dissolved, it can still continue to litigate. That's the law. But the dissent by Judge Atkinson is something that I favor, which Judge Atkinson was talking about a pay-to-play concept in the statute. And what Judge Atkinson's point is that dissolution doesn't bar the corporation from litigating, but when the corporation fails to file its annual report, the buck stops there. It's pay-to-play. That's not the law, but that's Judge Atkinson. And I tend to agree with that analysis. This is not what Judge Atkinson said, but something that I would tack onto that is if someone didn't pay an appellate court filing fee, the appellate court would dismiss the case. So I don't understand why a appellate court filing fee is any different than paying the Department of Corporations. But in any event, that's not the law. Corporation can continue. So next case, Brunage versus Evans, Judge Minkoff out of Pinellas County. There was a medical malpractice case, and the plaintiff in the pre-suit correspondence failed to provide an expert opinion with its notice of intent. After that, the doctor failed to comply with the informal discovery process, and the trial court denied the motion to dismiss, saying, well, the doctor failed to comply with the process, and that essentially waives any failure by the plaintiff to do it the plaintiff with respect to providing an expert opinion with a notice of intent. And the second DCA reversed, finding that the doctors, and I'm quoting from the case, the doctors failure to timely fulfill the informal discovery request did not waive the requirement that plaintiffs of intent. Boyle versus Samuelton, Judge Brody out of Collier County. There was a medical malpractice case based on an inadequate pre-suit notice. Apparently, the plaintiff properly alleged they sent the pre-suit notice to the doctor, but there was no proof that the doctor actually signed the return of receipt. And because there was no signature on the return of receipt, that didn't qualify for proper pre-suit notice. Now, the second DCA noted that there's a conflict in the DCAs about this issue. The fourth and fifth DCAs allow for mailing the notice alone to constitute receipt by the doctor, whereas the second DCA you have to show that the doctor actually signed the return of receipt. Likely to get taken up by the Florida Supreme Court, I would imagine. It's a pretty big distinction, whether mailing alone is enough or you have to show someone signed it, because what if someone just doesn't sign it? Okay, next case, Mace versus M&T Bank, Judge McHugh, Lee County, and the bank here failed to prove it mailed notice of default to the owner. The bank did not present any testimony by a witness with personal knowledge that the letter was mailed. The bank did not establish its routine practice for mailing default letters, and the copy of the certified mail card was insufficient because it was, quote, undated and lacks any indication of what correspondence it was intended to convey, and because, quote, the copy of the card contains no reflection that it was ever placed in the mail and no return receipt showing its delivery to the Maces. Okay, next case, Roche versus US Bank, Judge Muscarella out of Pinellas County. Here, there was a letter log from a bank, and it was not sufficient to show that notice was mailed because it was inadmissible hearsay. I'm quoting from the case, quote, the letter log had been created by the servicer after communicating with a third-party vendor responsible for mailing its foreclosure letters. This third-party vendor was not named, and the log was introduced through testimony of the servicer's employee, not an employee of the third-party's vendor. I thought there was a great quote from this case that could be used in other circumstances where people create a record that something happened, but it's secondhand or third hand. The quote is, US Bank's servicer cannot manufacture a sufficiently knowledgeable witness by merely creating its own record of a record. Okay, those were some notice condition precedent cases. Now we're on to arbitration independent judgment cases. And if you joined during this, go to the chat function. You'll get a copy of the demonstrative that we're going over. Each case as a hyperlink. You can read the case for yourself. I am giving you significant issues that I think could be applicable in other circumstances. There were over 500 written opinions, not PCAs, but over 500 written opinions in the second DCA. I reviewed them all. Don't have time to go over them all, so I picked about 70 of them out, and I created categories. So we're going through these categories. Okay, so here's some arbitration/independent judgment cases. First case, 4927 Voorhees Road versus Tesoriero. It's Judge Bird out of Pasco County. A nursing home was sued over wrongful death, and the nursing home invoked an arbitration agreement. And the trial court denied the motion to compel arbitration because there was a limitation on damages provision and an attorney's fees and cost provision that allegedly violated public policy. But the second DCA reversed, saying these arbitration provisions have severance in them, and the bad provisions of the arbitration clause, quote, are not the essence of the agreement, and just sever them away and enforce the arbitration agreement. I think a good takeaway from this case is put a severance provision in your arbitration agreement so that you can sever away anything that's the other person says may violate public policy. But the second DCA noted a conflict with the fifth DCA on this issue. Next case, Collier Condominium versus Forsman, Judge Creer out of Collier County. The trial court adopted a general magistrate's report and recommendations regarding granting a motion to dismiss. And the second DCA reversed, saying that the order doesn't address the issue of arbitration. And there was some internal inconsistency and conflicts with the magistrate's reports and recommendations and what the trial court actually did. So the reason why I selected that case is because the next case I thought was similar to it. And the next case is White versus Fort Myers. Judge Schenko out of Lee County. And here, the party said to the second DCA, the trial court adopted verbatim what the other side proposed in their judgment, and that's not fair. Trial courts can't just take what a party writes down and adopt it as their own. And the second DCA head-on addressed that issue and said, no, you're wrong. Florida law does not prohibit the verbatim adoption of a judgment that has been proposed by a party. However, we will reverse any judgment entered under circumstances that create an appearance that the judgment does not reflect the judge's independent decision making. And the second DCA went through the transcripts and said throughout the hearing, the trial court recited a summary of the facts and issues and actively engaged with the parties and made several oral findings. The takeaway from White versus Fort Myers and Collier Condominium versus Forsman for me is, number one, if you think it's going well, make sure the trial court says things on the record so that your proposed order is not just, your words, it's what the trial court says. Also, make sure that the oral pronouncements don't conflict with what you write down, because that's an issue. Okay, next case, Doe versus Airbnb. Judge Sniffen out of Manatee County. Apparently an Airbnb had some hidden cameras and there was a lawsuit for violation of privacy. And the second DCA found that the trial court could determine whether the dispute was arbitrable under the arbitration provision in the contract. The issue is whether an arbitrator had to determine whether the dispute was arbitrable or the trial court. And the second DCA said there's a presumed authority by the court that the court decide these issues, not an arbitrator. And the agreement didn't have clear and unmistakable evidence that the parties wanted to get rid of the court from making that decision. So the takeaway here is if you want an arbitrator to determine arbitrability, you've got to make it clear and unmistakable. The argument here is there's the AAA rules were referenced in the agreement, and somehow because the AAA rules allow for arbitrators to determine arbitrability, that means in the second DCA did with that. If you are not muted, do you mind please muting? Thank you. Okay, next case. Our next cases are some complaints and affirmative defenses cases. Picked out 4 of them. The first case is Drish versus Boss, Judge Minkoff out of Pinellas County. There was a cause of action for partition and unjust enrichment, and the trial court denied the motion for leave to amend because it was filed after the defendant moved for summary judgment. And the second DCA reversed, saying, well, this was the first time that the party moved for leave to amend. It was filed more than 2 weeks prior to the summary judgment hearing. There was no trial. It was the motion was filed only 6 weeks after the answer and affirmative defenses. This is a good case if you're trying to, if you're on either side of amendment. There are some good factors here to convince a court as to why motion for leave to amend should or shouldn't be granted. Jensen versus Pinellas County, Judge Muscarella out of Pinellas County. Now, this was a pro se litigant, so I don't know if this would have changed things. We're more lenient with pro se litigants, but in any event, the trial court dismissed the 5th amended complaint with prejudice, and the trial court said, this is a vague and abstract request for declaratory and injunctive relief. The pro se litigant was challenging an ordinance regarding the sale of firearms, and the second DCA reversed and said the trial court's order dismissing the 5th amended complaint with prejudice does not discuss why the complaint was vague and abstract. And in any event, vagueness and abstractness are motions for more definite statement, motions to strike. It's not a motion to dismiss language. So if you're doing a proposed order, or if you're trying to convince the judge as to language like this, an explanation goes a long way in the second DCA. Just saying it's vague and abstract didn't work here for why the motion for leave to amend should be denied. Okay, Deer Brook South versus Battles, Judges Radin and Radabaugh out of Polk County. There was a lawsuit regarding the foreclosure of a lien, and the trial court granted summary judgment based on statute of limitations. And the problem was the defendant did not raise statute of limitations and the affirmative defenses, and the second DCA reversed, saying, well, statute of limitations is one of those enumerated affirmative defenses that has to be affirmatively set forth in the pled, or it's deemed waived. And so because, and I'm quoting from the case, because the Battles first raised the statute of limitations defense in their motion for summary judgment and not in their pleadings, summary judgment on this ground was error. So yet another reason why you want to be fulsome in your affirmative defenses. Don't miss anything, because if it's not raised, you can't win on it. JAK Capital versus Adams, Judges Branning and Fuller out of Lee County, another example of this. There was a lawsuit regarding some property, and in the final judgment, the trial court refused to enforce the mortgage on the basis that it was, quote, procured by fraud. And the second DCA reversed, saying, wait a second, they never pleaded fraud as a defense to the mortgage, and so the trial court erred as a matter of law by providing them with relief on this unpleaded basis. Fraud is an affirmative defense that must be specifically pleaded. The defendants pled that, and they said to the second DCA, well, isn't forgery fraud? Isn't that sort of the same thing? And the second DCA said, no, forgery, just because you pled forgery, that's not the equivalent of fraud. Fraud means fraud. You got to plead it specifically. So be careful with the affirmative defenses. Okay, here are some summary judgment cases. 5 of them picked out. First one is Wendell versus Meese Hospital. It's Judge Jaroka out of Pinellas County. Somebody got a really bad bacterial infection from a hospital, and the trial court granted summary judgment for the hospital on the basis that plaintiff didn't meet the plaintiff's burden to prove that the infection was the hospital's fault. And the second DCA reversed, saying, you know, that's not the standard in Florida. The Florida, I'm quoting from the case, the Florida Supreme Court has held that on a motion for summary judgment, the party moved against has no burden to come forward with evidence unless the moving party conclusively proves the non-existence of a genuine triable issue of fact. So at trial, the plaintiff would have had the burden to prove a causal relationship between the hospital's alleged negligent acts and his injury, but on a motion for summary judgment, the burden was on Meese as the moving party, the hospital, to conclusively show that no causal relationship exists, and the trial of it is no longer required. So this is a significant case, in my opinion, on the standard for summary judgment. The burden is not shifted unless there's a conclusive non-existence of a genuine issue of fact. If you practice in federal court, you'll see that there's a significant tension between this standard and the federal standard, which shifts the burden in a different way. DCA noted that the Florida Supreme Court's actually taking up the issue as to whether to adopt the federal standard or this more sure what the status of it is, but this case could make things a lot to look out for that case. Svetlanovic, State Farm, Judge Muscarella out of Pinellas County. There was a claim for breach of contract regarding recovery of a lost diamond ring, and the trial court entered summary judgment against the plaintiffs and just said, you know, the plaintiffs are not credible. I don't believe them. Summary judgment for the defense. And the second DCA reversed, holding that the trial court erred by making, quote, an assessment of the weight to be given to certain evidence and an assessment of the relative credibility of the witnesses. Those are jury issues. So credibility and weight, that's not something that should be going on. In McElroy versus the Oaks on the Bay, Judge St. Arnold had reversed the trial court's summary judgment ruling because the ruling was entered without a hearing. The story on that is the losing party in summary judgment had engaged in, quote, dilatory conduct during discovery. Attorney withdrew while written response to summary judgment and didn't show up to a case management conference that was before the summary judgment hearing. And apparently, it's not clear from the opinion, but apparently what happens, they discussed the dilatory conduct, and it looked like the trial court just granted summary judgment. Hey, there's no response, just grant summary judgment without a hearing. And the second DCA said, there's no indication in the record that the party waived the right to be a motion for summary judgment hearing, despite doing all this stuff that's not good. So entry of summary judgment without a hearing is a per se violation of due process rights. Okay, next case, Rodriguez versus Avatar Property. It's Judge Battles out of Hillsborough County. There was a breach of insurance contract and a water damage in a bathroom. And the second DCA reversed summary judgment because the affidavit the insurance company put forward wasn't sufficient to establish summary judgment. Now, this case, you've probably seen it before, like an affidavit that comes into a summary judgment proceeding or some other proceeding that's like hundreds of pages long, and it's like perfect prose. Supposedly a non-lawyer wrote it, but it seems like an army of lawyers was behind it. There's citations to case law and all that. And the second DCA was faced with one of these things here and said, no, we're not going to allow basically a crafted affidavit to support summary judgment. There's some good language here if you're facing an affidavit like that as to why a court shouldn't give it credence. Quote, the affidavit states only that the person was a duly authorized corporate representative of the insurance company. It doesn't even identify her title or specific corporate duties. The affidavit lacks sufficient information to allow the court to conclude that she possessed the competency to testify to the matters set forth in her 37-page affidavit, which includes statements ranging from contract interpretation to trade specialties, plumbing, and contracting. Like, this person knew everything under the sun, and it all proved the case. The second DCA said affidavits like that are not going to work for summary judgment. Okay, Watts versus Getz, Judge Creer out of Collier County. There was a malpractice case against a lawyer for failing to include a supportive relationship clause in the settlement agreement, and the trial court said, you know, how can the plaintiff win where the modification of the prenuptial agreement was an impossibility because the prenup wasn't challenged in the divorce proceedings. Logical. But the second DCA, and the reason why I'm quoting this, you'll see in a minute, said summary judgments should be cautiously granted in negligence and malpractice suits. And apparently there were some issues about whether the prenup could be modified, and let's be cautious about this malpractice suit regarding a supportive relationship clause in the settlement agreement. So the second DCA overturned it. But now going on to some negligence cases with this concept, summary judgments should be cautiously granted in negligence cases. There were a ton of negligence cases in the second DCA that got overturned. A lot of them were slip and fall, but I think it drives home the point, as you'll see, that if you're the plaintiff in a negligence case facing summary judgment, things are pretty good for you in the second DCA, it seems to me. Here are some examples. Green versus Twisty Treat. Somebody slipped and fell in the pavement at an ice cream shop, and the trial court granted summary judgment, and the second DCA reversed. Quoting from the case, a jury could conclude that the hole in the pavement was not so open and obvious that the defendants could reasonably expect that it would be discovered by an invitee, such as the plaintiff. A jury could conclude that the defendants reasonably should have anticipated that an invitee negotiating the parking lot to visit the ice cream shop would be distracted. So next case, Frederick versus Dollar General, Judge Laboda, Lee County, another slip and fall. This is like liquid laundry detergent in a store aisle. Trial court granted summary judgment, second DCA reversed. Quoting from the case, the store manager testified that he should have told the other employee about the spill, that she could have quickly warned plaintiff as he walked in the store, and that he could have quickly blocked off the spill, and that plaintiff's fall was preventable. So another negligence case, Norman versus DCI Biologicals, Judge St. Arnold Pinellas, another slip and fall. This was in the bathroom of a plasma donation center, and the trial court granted summary judgment in favor of the plasma donation center. The center didn't have constructive notice of the wet spot in the bathroom. The second DCA reversed. There was a disputed issue of fact as to whether the water was there long enough for the plasma donation center to have known about it. There were muddy footprints. There was another skid mark. Quoting from the case, the plaintiff also adduced circumstantial evidence to support an inference that no inspection of the men's donor bathroom was conducted during the entirety of the busy day. So another negligence case reversed on appeal. Brannick versus Pinellas County, Judge Allen out of Pinellas County. This at the trial level, summary judgment was granted in favor of the county regarding a bicycle accident and a drainage ditch, and the second DCA reversed. So there was an issue of fact as to whether the county should have known about the drainage ditch that caused the injuries. So yet another case overturned on appeal. Vogel versus Cornerstone Doctors, Judge Muscarella out of Pinellas County. A patient at a doctor's office tripped when entering the elevator. There was like a 24-inch gap, and the trial court issued summary judgment for the defendant. But yet again, the second DCA reversed that, saying a jury could reasonably infer that Cornerstone negligently failed to examine the elevator or to have it examined by an experienced technician to determine what was causing the intermittent problem. And it's possible that a jury could reasonably determine that Dr. Robeson's check of the elevator was a reasonable response to the out of order signs. However, it's also possible that a jury could determine that a reasonable owner would have contacted the elevator company to have the elevator checked rather than taking the matter into his own hands. So just going back to this quote from Watts versus Getz, summary judgments should be cautiously granted in negligence cases. We saw that in the second DCA, a ton of negligence cases were overturned on appeal. So if you're a plaintiff with a negligence case in the second DCA, I think things are good for you. Here are some other tort cases. Sturgill versus Lucas, Judge Schenko had a Collier case, a tractor trailer carrying palm fronds, waiting at a bus stop with the grandkids. And the trial court granted summary judgment in favor of the owner of the tractor trailer. He wasn't driving it at the time this happened, but he had loaded the palm fronds onto the truck. There was like a ton of palm fronds. And there was maybe some issue about whether it was too heavy and it might have caused the truck to swerve. And the trial court said, there was brakes and nothing that the plaintiff had cited. They didn't cite any law, statute, rule, or regulation requiring someone who loads palm fronds onto a truck to be liable. And the second DCA reversed, saying, hold on, there are different ways that you can create a duty, the statutes, common law, other sources, but then there's this catch-all general facts of the case. And we think the general facts of the case should go to a jury. You can't rule as a matter of law the owner didn't have a duty to the grandmother. Another case, another horrible case, Lambert versus Emerson, Judge Groger out of Pasco County. A son used a family car and it caused serious injuries. And the jury verdict was against the mother. She wasn't the owner of the car, but she made the decision to let her son use the car that day. And the second DCA found that the mother could not be liable as a matter of law. Although the jury, quoting from the case, though the jury determined that she was the bailee of the Sonata, that is not a basis upon which vicarious liability can be applied under the dangerous instrumentality doctrine, since Mr. Lambert, father, the undisputed title owner, had also been found vicariously liable for what is essentially the same entrustment of the same vehicle. So the owner was liable, the dad, not the mom. Okay. Next case, Neapolitan Enterprises versus Fishman. Judge Brody out of Collier County. There was a defense verdict, jury verdict, in a slip and fall, and the trial court overturned the verdict because the defendant introduced evidence at trial that the plaintiff had Parkinson's disease, but the plaintiff didn't have Parkinson's disease. Like, it just wasn't his disease. Apparently, there were some medical records that were inadvertently given to the defendant, and the defendant put those in the trial record. It's a little confusing as to whether they were shown to the jury or when they were shown to the jury, but they were in the record nonetheless. And the trial court said, yeah, you didn't have Parkinson's disease. We have to overturn this verdict on newly discovered evidence. And the second DCA said, no, you waited 5 months after judgment to bring this issue up. That's not diligence. I mean, you're at the trial, you saw the records, you can't wait 5 months. So newly discovered evidence doesn't overturn a jury verdict. After 5 months, you find out there was a bad record. Maybe some other rule, but the second DCA said this jury verdict could not be overturned on newly discovered evidence, even though the wrong medical records were given to the jury. Okay, so here are some sanctions cases. I put these out here just to see that sanctions happen, and there's a lot of scenarios where a lot of sanctions happen in a lot of different practice areas. Okay, Schur versus Silverio and Hall, Judge Foster out of Collier County. There was a frivolous motion to adjudicate a charging lien against other lawyers, and the second DCA actually overturned the order denying the motion for sanctions, finding that the lawyer should have been sanctioned for filing a charging lien against other lawyers, because to claim that these other lawyers somehow took the money was just frivolous. You can read the opinion. Residents for a Better Community versus WCI Communities, Judge McHugh out of Lee County. A party filed a notice of voluntary dismissal, and after dismissal, the other party filed a motion for 57-105 sanctions, and the trial court was reversed. The second DCA found that the trial court did not have jurisdiction to entertain the motion for sanctions because it was filed after voluntary dismissal. Next case, in re guardianship of Fern Davis, Judge Brody out of Collier County. The trial court had issued sanctions based on inherent authority, and the second DCA overturned it. There's not a lot of detail in this opinion, although the second DCA said, although the proceedings below were not conducted in an ideal manner. The reason why I cite this case is, tell your clients bad stuff can happen in cases if people mess around, and it's true. And the second DCA is not always there to reverse it if there isn't a sufficient record or whatever. So this is an example of someone getting sanctioned for proceedings not being conducted in an ideal manner. Granted, it was overturned, but maybe not in every case. Okay. Ballard versus Bank of America, Judge Allen out of Pinellas County. The trial court entered a default as a sanction against a party for failing to respond to discovery and failing to timely file and answer an affirmative defenses. And the second DCA reversed and remanded for the Kozel factors to be implemented, which are very specific factors if you're going to get dismissal for failure to respond to discovery request and timely file and answer an affirmative defenses. In re guardianship of Roland T. Martino, the second DCA upheld sanctioning of a party for filing a frivolous objection to a guardian's petition for fees because the party had no standing to object. And some good language there if a pro se or somebody's messing around. Okay, Deutsche Bank versus Bennett, Judge St. Arnold out of Pinellas County. The trial court dismissed the action without prejudice as a sanction for untimely and incomplete production documents. Didn't give the documents on time, and it was incomplete, dismissed. The second DCA upheld it and said because the dismissal was without prejudice, the trial court didn't even need findings of willful disregard. Now, there's a conflict among the DCAs on this, but it's pretty serious in the second DCA. You can get sanctioned, so in any event, for not producing documents timely or completely. Okay, on to some criminal law cases. We have about a little less than 15 minutes left, so I'm going to start running through these cases a little faster. Ryan versus State, Judge Quesada out of Pinellas County. The sentence was overturned given some statements the court made at the sentencing that suggested the court departed from his role as an impartial arbiter. There were some comments about playing with the judge and taking it out on the defendant if the defendant required the state to prove his prior convictions. Department of Highway Safety versus Charkin. This is a second tier review from Manatee County. This person had been convicted of DUI manslaughter and wanted his license reinstated. And for the hearing on that, the statute says that the person needs to be drug-free 5 years prior to the hearing, for continuous 5 years prior to the hearing. And at the hearing, he admitted that he had a beer. He had one beer a week before the hearing. He thought it was a Coke, a can of Coca-Cola from the refrigerator, but he drank it anyway because he didn't think it would matter because he wasn't driving anywhere. And the second, this is a very long opinion. There's a lot going on here, but the second DCA said that one beer is not drug-free and it disqualified this person from getting reinstatement for the purposes of the driver's license. Now, I wonder whether the result would have been the same if he didn't say this. I thought it was a Coke thing, but in any event, it's an interesting statutory construction, but one beer is not drug-free. Okay, Edwards versus State, Judge Nazaradian out of Hillsborough County. There were some curfew checks at 5 and 5:30 a.m. for a probationer, and the probation officer didn't see anybody or hear anybody, so they violated him for probation. And the second DCA said, hold on, they could have been sleeping. You know, there was somebody on the couch sleeping. You didn't wake anybody up. That wasn't a sufficient curfew check, especially at 5 and 5:30 a.m. Same sort of thing in Gorman versus State. Next case, Judge Thompson out of Lee County, violation of community control for failure to remain confined to a residence. And, you know, the lights were off and the blinds were drawn. That doesn't mean the person wasn't there. If you compare those two cases with the next case, Timke versus State, Judge Nazaradian out of Hillsborough County, the second DCA found that the trial court properly revoked probation and sentenced this defendant to 201 months in prison for being 26 minutes late to curfew. 201 months in prison for being 26 minutes late for curfew, excuse me. Apparently the defendant admitted that he went to like downtown Orlando and didn't really account for traffic. And the second DCA said, no, you cannot blame traffic for this issue. You're going to prison for 201 months for being 26 minutes late. Youch. Okay. Wiley versus State, Judge Kyle, Lee County. Some drug possession convictions were reversed. This is interesting if you're a prosecutor or a criminal defense practitioner. There was a thumbprint on the lid of a jar containing drugs, but that wasn't enough to show that the defendant had constructive possession of the jar of drugs contained within a safe in a jointly occupied bedroom. The second DCA's analysis was the thumbprint was on the inside of the lid of the jar containing marijuana, but there were no other items inside the safe that might connect the contents to any particular person. The home and the master bedroom were jointly possessed, and the state didn't present proof of independent control. Some motions to suppress cases. Bent versus State, Judge Roddenberry out of Polk County. Somebody was parked at the fog line, the driver's side, 2-lane road, and the second DCA said that the stop was illegal because just because they stopped on the side of the road didn't mean that they intended to obstruct traffic laws. Next case, Fields versus State, Judge Porter out of Lee County. There was no reasonable suspicion for a 911 call based on a loitering and prowling. Apparently, you know, this person had been jiggling the lock of a door handle, and somebody called and was very concerned. And the second DCA said, well, you know, jiggling a door lock, you know, could have been an invited guest, and maybe the residents didn't hear the person. So it's consistent with both criminal and non-criminal activity. The stop is no reasonable suspicion. Next case, Townsend versus State. Second DCA did not find reasonable suspicion for a pat-down search just because this person was in the same house as someone else who had committed a robbery 12 hours earlier. Just because he was in the same house as someone who committed a robbery 12 hours earlier didn't warrant a pat-down search. Okay, Parker versus State. A probationer had used his cell phone to effectuate flying a drone over a victim's condominium complex, and the trial court properly denied a motion to suppress the warrantless search of the phone. The phone could be given up without a warrant because he used the phone to help fly a drone over a victim. NGO versus State, Judge Williams out of Hillsborough County. This person asked for somebody to be present during questioning, and that was sufficient to trigger Miranda. Here are some contracts cases. We have about 7 or 8 minutes left, so I'm going to try to fly through this. Schlechter versus Community Housing Trust, Judge McHugh out of Sarasota County. Enforceable because reserve any jurisdiction to the trial court, nor did the stipulation of dismissal with prejudice. So the trial court had no jurisdiction because jurisdiction was not reserved. So reserve jurisdiction if you want the court to enforce a settlement agreement. Suarez Trucking versus Saunders. There was a notice of an acceptance of a proposal for settlement, but that didn't create a binding settlement. There was a boilerplate acceptance, didn't really specify what terms were agreed to. And then when the person wrote the check, the insurance company wrote the check with the boilerplate notice, it changed the payee, and the payee, changing the payee changes the terms of the settlement, and it's a repudiation, it's not an acceptance. Drapp versus McDaniel, Judge Allen out of Pinellas County. This person sought to invalidate a deed, blaming lymphoma, which is horrible, but blaming lymphoma on the fact that the person didn't have the mental capacity to sign the deed and we needed to invalidate the deed. And the second DCA reversed, saying there's no testimony that the illness affected this person's mental capacity or was otherwise mentally incapable of signing the deed. And by the way, there was a notary who thought that everything was fine. And the trial court apparently shifted the burden onto the defendant to prove why it shouldn't be invalidated as opposed to the other way around. Here are some injunctions cases. Washington versus Brown, Judge Weiss out of Hillsborough County. There were like 28 pages of text messages and social media posts that were really nasty. But the second DCA said cyber stalking injunctions not okay in this scenario, just because the person was evoking resentment and anger. That's not cyber stalking. Another case, Kraft versus Fuller, Judge Labruzzo out of Pinellas County. The trial court granted a cyber stalking injunction for tweets, and the second DCA overturned that one too. Apparently these people had been friends and business partners, and somebody was making fun of another person's arrest for spoofing and said spoofing schmuck and other unflattering things in tweets. And the second DCA said no to cyber stalking injunction and said, you know, injunctions are not a panacea to be used to cure all social ills. Nowhere in the statutory catalog of improper behavior is there a provision for court-ordered relief against uncivil behavior. Another case, Barrett versus Busser, Judge Perone out of Hillsborough County. A lawyer had miscalendared a final injunction hearing and told his client not to come because he thought it was like a status. And at that hearing, the trial court issued a 10-year injunction against the client, 10 years. And the second DCA said that the trial court should have had an evidentiary hearing as to whether there was excusable neglect for the client not coming. Okay, we have a couple minutes left, and the last series of cases, I want to try to get through them all. In the interest of TC and AC, Judge Greeter out of Collier County, this is an interesting one. The trial court should not have required the children to have been vaccinated against the mother's wishes. So I wonder whether this is a really interesting analysis, and I wonder whether this will apply in the COVID world. You know, it was non-required enrollment in a daycare program, but maybe it's different in required enrollment in school. I don't know, but stay tuned for this analysis. I'm sure we're going to see vaccine cases. LEB versus DDC, Judge Hawthorne out of Lee County. This order granting disqualification of legal aid attorneys was reversed on appeal. This party waited over a year to say that the legal aid should be disqualified. Like they had filled out a legal aid intake form and then couldn't, you know, they didn't qualify for legal aid, and then legal aid sued them, and they waited over a year to make an issue of it. So that was a waiver of disqualification. And the second DCA overturned the order granting disqualification. Okay, Burke Products versus Access Electronics, Judge Laboda out of Lee County. There's a breach of contract case against an Ohio corporation, and a great quote from this case regarding lack of jurisdiction. A choice of law clause in an agreement is insufficient by itself to confer personal jurisdiction. Next case, Helix Electric versus Powered Design, Judge Minkoff out of Pinellas County. Another motion to dismiss based on lack of jurisdiction. There was a tortious interference case, and the second DCA reversed, saying that there was insufficient jurisdiction. And just because there was a breach of a Florida contract and loss of income to a Florida corporation, that was, quote, immaterial for the purposes of determining jurisdiction. Another case, Barodi versus State, Judge Roddenberry out of Polk County. The second DCA did not like these arguments the prosecutor made. Spaghetti is getting thrown over our heads. It's all just been to me smoke and mirrors. This is starting to feel a bit like an abusive relationship. This is good fodder for a motion in limine if you think there's some aggressive advocacy on the other side. Robinson versus Polk County, Judge Self out of Polk County, a student athlete was awarded $125,000 in damages for abuse by a football coach, pinched his nipple and swore at him. And there was a jury verdict in favor of the student athlete that the trial court overturned because the trial court thought that the plaintiff might have taken his shirt, was like trying to take his shirt off or showing the jury he was going to take his shirt off. And that somehow tainted the verdict. And the trial court said, it's a close call here. I can almost do a coin flip on this. And the second DCA said, no, that's not the right analysis. There's a bunch of factors you have to take into account. This isn't a coin flip. Last case, Harrell versus Universal Property, Judge LeBode out of Lee County. The second DCA affirmed the trial court's denial of prevailing party attorney's fees. And this is in the weeds, but prevailing party issues come up a lot. A dismissal without prejudice after the expiration of the statute of limitations period and the expiration of the period allowed to accept a proposal for judgment is not an adjudication on the merits. Okay, I don't want to keep you longer than an hour. I went a little bit over, but this was a free 1 credit hour Florida bar approved CLE. The reference number you see on the screen here is what you need to plug in at floridabar.org to get your CLE credit. This CLE covered about 70 out of over 500 opinions handed down by the second DCA in the year 2020. I read them all. This was just some high points with, and this demonstrative has links to the cases. You can read it. The CLE was conducted by my for-profit company, the Florida DCA Wizard, which provides real-time updates of cases as they come out, sort of like what you saw in the demonstrative with links to the cases. So you don't have to read the 15-page opinion. You can look at the top line and read it if it draws your interest, the summary. If you liked what you saw here, there's some more upcoming free Florida bar approved CLEs that I'm doing. Tomorrow, I'm doing the 4th DCA year in review. That's 2 hours because there's, believe it or not, a lot more that happened in the 4th DCA. In January, I'm doing a 3rd DCA year in review. That's also a lot of opinions. That's also 2 hours. Short while ago, I did 4th DCA in the 4th quarter of 2020. That's on YouTube. You can watch it. And if you want a copy of the demonstrative, sort of like the one you saw here, I'll email it to you. If you want to email me about upcoming CLEs I'm doing, I'm happy to send you notice about it. And if you want to subscribe to my service, it's $25 a month to be updated on one DCA, $50 a month for all the DCAs in the Florida Supreme Court. And if you want all the summaries for any DCA for the year 2020, it's $250. Thank you very much for your time. I hope there was something here that was helpful to you, and have a nice new year. Thank you.